Well, Mr. Cooley, you have me in a difficult position because I want to proceed with this, and I think we need to get on with it. And I know and I've given you time to retain an attorney, but I know you have the right to hire an attorney, and I know you should hire your attorney because you've got the money to do it. I'm Robert Cooley.
I have him here with us, Judge.
All right, Mr. Patterson, will you have the same announcement on Mr. Cooley by chance?
No, Judge, I did review the file on that one. I can see where he did put in an application for court-appointed counsel for the probation violation. I see on the court docket though it shows denied.
Okay, we'll be on the record in 2023 TR 1167, State of Kansas versus Robert Andrew Cooley. Jared Regier appears for the state. The defendant appears in person and pro se. His probation officer, Ryan Smith, is here as well on this hearing on a motion to revoke probation. You did turn in an application, Mr. Cooley, for appointed counsel, and the response to that motion filed January 18th of 2024. Well, Mr. Patterson, January 18th of 2024, I am showing that you were appointed.
Judge, and this is just for the PV. He put in an additional new one in 2025. And in 2025, the notations on full court under the application is that it listed denied.
And Your Honor, if I may.
Well, he has two cases. Yes, Mr. Regier.
It would appear that at the last setting on March 12, the court did make a finding that the defendant did not qualify for court-appointed counsel and the defendant was to retain his own attorney.
Well, I'm looking at 2023. He's got two cases today on the docket. We're here on 1542 and 1167, both 2023s. The last docket, oh, wait. Okay, flip the page again. All right, thank you. Notes in terms. Okay, March 17th, there was originally an appointment, but as Mr. Patterson said, for the show cause application denied. Okay. Let's see. Based on the information that you supplied about your income, it did show you're employed at Courtroom Plus, making somewhere between $2,800 and $300 per month. You pay $1,000 in rent. Looking at that again, I am not sure why that would have been denied. Well, if you were making $2,000 a month, you would have qualified, but at $3,000 a month, $2,800, let's say $300 a month, you should be having about half your disposable income still available. That's why you were denied.
Ma'am, I think the mistake I might have made on the application was there was for my spouse, what she also makes, and we are not on the same, we don't, share money, we don't pay bills together. So that I stated that on the application for.
Let me see, I don't know that you did put that on here. You put that you yourself are making about $2,800 to $3,000 a month, and that your expenses are well, I can't tell if that's $1,250 or $1,750, but if I give you the benefit of the doubt that it's $1,750, if I take the low end of what you say you're making, $2,800, and I take the high end of what you say you're paying out of $17,500, you still have about $1,050 a month you could pay towards attorney fees.
Right. And I actually have monthly statements of what I make a month. On a good month, I'd probably make about that $3,000, but on a normal month, I barely break $2,400. So I will say that, and I do have proof of what I make monthly.
Okay. What did you put on your tax return for this past year?
I actually paid in on taxes this year.
You know what your income was?
I think we were around, I cannot remember off the top of my head.
Okay. Well, Mr. Cooey, at this time, I'm not finding that you do qualify. Are you able, do you have the money available now to go out and hire an attorney?
I do, but I will not have the funds up until Wednesday. That's when my direct deposit will come in. I have been in contact with an attorney. He's just working on trying to get some of his cases out the way. Mine came up really fast for him, so he's really trying to get it worked out.
Well, who are you working with?
I don't know how to say his last name. He goes by Joe.
Favre?
Yeah.
State's position on continuing this a short period of time to allow him to hire Mr. Favre?
Your Honor, while the state does acknowledge there is a constitutional right to counsel in these types of situations where a liberty interest may or may not be at issue, the state does have some concerns about setting this matter over again. It would appear that the request for revocation was originally heard before the court on March 12th, and the court did set over to today's date and time with the court finding that the defendant was to hire his own attorney. It appeared that based off the defendant's statements made on the record day, there have been certain conflicting statements made at this point. So the state is not aware. The state does have concern about saying this matter over again, having already subpoenaed the court services offer to today's hearing, and the state is eager to reach resolution in this case.
Right. And I want to correct the record. I believe he does just have the one case. I believe the other case number may be Mr. Lott's client. I think that may go to Cooper. Mr. Lott's, does that sound right? That 1542, I believe, goes to Mr. Cooper. Mr. Cooey, you're certain that you have the money coming this week to pay Mr. Favre?
Yes, ma'am.
You're certain of that?
I am.
As certain as anyone can be of anything in the future. You are on appearance bond for today and for this motion. Okay, the warrant to show cause was filed November 28 of 2024. The warrant addressed allegations that the defendant had failed to report, that he had failed to pay, and he'd failed to refrain from using illegal drugs. And that was based on, I believe it was like in June that he was appointed. Mr. Smith, is it your allegation that he has not reported since then, or has he?
Your Honor, he has not, other than a couple of telephone calls that he had called.
So the state's objecting to the continuance, is that right?
If the court is inclined to grant a continuance in this matter, the state would have its objections noted on the record, Your Honor.
And Mr. Cooey, are you asking for a continuance or?
Ma'am, I would really like the opportunity to find a proper representation for myself. I think that's the best thing I can do for me at this point. And yeah, I would really like the time.
Well, I'm hesitant to give you time because you've had since June to see your probation officer, and the officer's saying you haven't. You've had some failures to appear, and I don't want you to disappear again on me if you don't come up with the money for Mr. Favre.
Ma'am, I can personally say, like, I'm ready to have this behind me, I think, just as much as the court is. I've made sure I was here at court every time I've been asked to be at court.
Well, since the show cause, I don't think you were originally.
Right, yes. Like I said, I'm willing to come clean with the thing I've, done wrong here. I would really like to have representation with me here. And I can promise you guys I will be here because, like I said, I am ready to have this just as much as behind me as everybody else.
Your Honor, may the state be heard briefly on this matter?
Certainly.
Your Honor, in reviewing the prior notes from this case, it would appear that there had been 3 prior failures to appear in June and October of 2023, as well as in April of 2024. So it would appear that this is a case with a notable history of failing to appear, at least in this particular case. So again, the state does have some concerns with reaching a timely disposition in this case, given the particular facts and history of this case.
Mr. Cooey, what's going to give you the money to make him hired? What's happening in your life to get money to hire him? You said Friday?
It would be Wednesday. It would be a Wednesday night. So technically Thursday morning, but it would. That's when I get paid. That's when I get a paycheck from work. I get paid weekly. So,
And that will give you enough money to hire Mr. Favre in full to represent you. Okay, did the camera at the security freeze? Looks like the camera at the security is frozen. I've never seen that happen. And now I remember where we left off. It was on Cooey. So we're back on the record in 2023, TR 1167, State of Kansas versus Robert Andrew Cooey. And I remember all the discussions about not being eligible for court appointed and going to give money on Wednesday to attorney Joseph Favre in Wichita, and state objecting to the continuance because it has subpoenaed, and Mr. Smith has responded to that subpoena. Mr. Smith, what does your schedule? Well, here's the thing. If he hires Mr. Favre, the chances of Mr. Favre being ready to go Monday is slim to none. Have you talked to the attorney about being ready to go anytime soon, Mr. Cooey?
I talked to him. It was last Friday. He said he was pretty busy. Even if I would have been able to pay today or then, he would not have been ready for today. Between everything else he has going on.
What I'm contemplating is appointing Mr. Patterson, but ordering you to be responsible for his bill.
Okay.
Is that anything at all you'd be interested in, Mr. Cooey?
Yeah, at this point, yeah.
Mr. Patterson, if I appoint you but order him to pay your bill, would that be something that you could arrange with him that you'd be willing to do? Is that anything appropriate?
I will do whatever the court orders, but that sounds a little odd to me that
All right. Well, do you
I
want
would
to?
be ordered a retained client.
Yeah, that does seem a little weird. That's why but I know that you could get in there and get this done probably with your eyes closed in your sleep and do a very good job of it. And I know Mr. Favre could too, but he doesn't have his schedule blocked like you do for these cases.
I fully understand, Judge. I also don't want to take work away from another attorney. I would.
Well, that's a point too.
But of course, I will comply with whatever the court orders.
Well, Mr. Cooey, you have me in a difficult position because I want to proceed with this, and I think we need to get on with it. And I know and I've given you time to retain an attorney, but I know you have the right to hire an attorney, and I know you should hire your attorney because you've got the money to do it. I'm going to continue this 1 week, and we're going to have Mr. Favre be here. And if he can't, then you need to get yourself another attorney.
Yes, ma'am.
And you better be here at the courthouse. If I have to chase you for another year or if I have to have officers chase you for a year, this is not going to be very satisfactory. So I'm going to continue this to 9 a.m. 1 week from today. What is that? April 6th?
April 7th, Your Honor.
April 7th at 9 a.m. You and your attorney must be here. Mr. Smith, I don't know if you want to be here because this will probably not be evidentiary, but are you able to?
I can be available, Your Honor.
All right. Well, thank you. I appreciate that. This is most troubling situation for the reasons stated. Your bond will continue, Mr. Cooey, and you must, under all circumstances, be back here in person at the courthouse like you are today.
Yes, ma'am.
And if you can get Mr. Favre here, he better be here, or you better have another attorney ready.
Yes, ma'am.
If you want to privately hire Mr. Patterson, if you want to privately hire John Doe if he exists, I don't care. That's your call to make, but you better be here with an attorney, especially
ma'am.
since you tell me you've got the money to do that. And your figures show that you should. Anything else, Mr. Regier? I'll note that you object.
Thank you, Your Honor. And it would appear that the court is giving this defendant a significant amount of leeway, given that he has previously demonstrated financial wherewithal by his ability to make a $3,000 professional surety bond. The state would have it noted object on the record, in addition to its objections, that the state will be objecting to any additional continuances at the next hearing.
And I understand and appreciate and share what you're saying, but I also know how the Court of Appeals are real precise in their interpretation of right to counsel, even if I don't know at what limit they would. Well, anyway, strike that. We will reconvene April 7th at 9 a.m. And I'm going to, at that time, consider Mr. Cooey. I've done everything I could to give you a right to counsel, and you've had every chance to appear with counsel by that point.
I appreciate it.
All right. Thank you, sir. You may go at this time on bond. We are on the record again in 2023, TR 1167, State of Kansas versus Robert Andrew Cooey, with Jared Regier for the state, Darren Patterson for the defendant, who appears in person and pro se, and we have probation officer Ryan Smith. Announcements, counsel?
Thank you, Judge. Your Honor, at this time, I would announce Mr. Cooey is going to waive hearing. He is going to stipulate to the violations listed, which are failed to pay as directed, and failing to refrain from the use of illegal drugs, specifically marijuana.
And Mr. Cooey, that is your intention. You wish to waive your right to hearing and stipulate to violations, as your counsel just stated?
Yes, ma'am.
Is anyone making you do this today?
No, ma'am.
And you understand you could be found in violation and ordered to serve the balance of your sentence?
Yes, ma'am.
Very well. I will find that you have knowingly and voluntarily waived your hearing and stipulated to violating your probation. I find that you have violated your probation as alleged. Revoke your probation. Mr. Regier, any recommendations at this time?
Yes, Your Honor. Pursuant to plea negotiations, the state is prepared to recommend a 10-day sanction to be served over 5 consecutive weekends. That reporting probation in this matter be extended for a period of 12 months from today's date, that the defendant further be ordered to complete and follow all recommendations of a drug and alcohol evaluation. As far as any credit for time served, the state's understanding the case law is the defendant is entitled to that, and the state is not opposed to that being assessed insofar as the underlying sentence is concerned. However, the state is not recommending that the defendant receive any credit towards the 10-day sanction if the court is prepared to adopt the recommendations.
Very well, Mr. Patterson, that is your agreed upon joint recommendation.
Your Honor, it is. We would ask court to adopt that for a few different reasons. This is the first warrant to show cause, but in addition to that, he does have gainful employment at cause, has been employed there for some time, and does wish to keep that employment. It will help him get through the terms of probation, and he does ask the court to allow the weekend service from Friday at 7 to Sunday at 7 for 5 consecutive weekends.
Beginning this weekend?
Yes, Judge.
Okay. All right. Mr. Smith, is that agreeable to you as probation officer?
Yes, it is, Your Honor, for the reasons that were previously stated. Yes.
Very well. Mr. Cooey? As I said, you've been found in violation of probation, and I could just go order you to serve the rest of your sentence. The officer there could just take you into custody, have you driven out to the county jail, and there you'd be. If I follow these recommendations, am I going to see you back here on a second warrant to show cause in a while?
No, ma'am.
You got that this is something you need to do or you face the consequences long term?
Yes, ma'am.
All right. We don't always get a second chance in life, but I will go ahead and follow the recommendations. Starting this coming Friday, I believe that's Friday the 11th, 2025. You must check in at 7 p.m. to the Butler County Judicial Center. You will serve 48 consecutive hours in the county jail. Then you'll do that again for the next 4 weekends after that. This must be 5 consecutive weekends. This time that you serve will count off of your overall sentence, but you must actually serve each of these 10 days in the time required. Your probation will be reinstated for 12 months starting today. You must comply promptly with every remaining condition. And have you gotten the evaluation?
I have not.
I'm going to order that you call and have that set up. Within 7 days, you're to call and get an appointment.
Okay.
And then you're going to get the evaluation and you're going to promptly follow all of its recommendations.
Okay.
Some might think you're getting by fairly easy today, others may not, but I don't think you'll get by as easily if you come back here on another violation. So make sure that you stay in touch as Mr. Smith tells you and do what he tells you, because he can be your line between here and the county jail.
Yes, ma'am.
All right. Anything further from anyone?
Your Honor, is the court making any orders concerning credit for time served for purposes of the journal entry?
But my order is, as you suggested, that the 10 days will count against his overall sentence, but nothing he may have served to date counts against his 10 days. As these are a sanction, he must serve each of the 10 days as ordered.
Very good, Your Honor.
Thank you.
Nothing further, Judge.
All right, then Mr. Cooey is excused. Mr. Smith, have you anyone else on the docket?
No, Your Honor, and if Mr. Cooey could report directly to my office following the hearing today, I would appreciate that.
That's the order.
Thank you, Your Honor.
You're welcome.
This hearing involved Robert Andrew Cooey, who appeared before the court on a motion to revoke probation in a Kansas criminal case. The proceeding focused on Mr. Cooey's alleged probation violations, including failing to report to his probation officer, failing to make required payments, and using illegal drugs. At the beginning of the hearing, the court addressed Mr. Cooey's request for court-appointed counsel. After reviewing his financial information, the judge determined that he did not qualify for a public defender because his reported income and expenses indicated that he had sufficient disposable income to hire a private attorney. Mr. Cooey argued that his income varied and that he had already been in contact with a private lawyer, Joseph Faber, but needed additional time to secure representation. The prosecutor strongly objected to another continuance, noting that the case had already been delayed and that Mr. Cooey had a history of failing to appear in court. Court records showed multiple missed appearances dating back to 2023 and 2024, raising concerns that further delays would prevent the case from reaching a timely resolution. Despite these objections, the judge emphasized the importance of protecting a defendant's constitutional right to counsel and reluctantly granted a 1-week continuance, warning Mr. Cooey that no further excuses would be tolerated. When the case returned to court, Mr. Cooey, represented by counsel, chose to waive his right to an evidentiary hearing and admitted to the probation violations. In exchange, the prosecution recommended a negotiated resolution rather than seeking full revocation of probation. The court accepted the agreement, imposing a 10-day jail sanction to be served over 5 consecutive weekends, extending probation for an additional 12 months, and ordering Mr. Cooey to complete a drug and alcohol evaluation and follow all recommended treatment Before concluding, the judge warned Mr. Cooey that he was receiving a significant second chance.
This court
While
hearing
avoiding a
concerns the
potentially
case of
much
State of
harsher
Kansas
sentence,
versus
he was told
Abel
that any
Estrada
future
Jr., who
violations
was
could
previously
result in the
convicted for
complete loss of
displaying
his
an unlawful
probation and
license plate
immediate
on his vehicle.
incarceration.
The court